I'll just make a couple of points, and then there's about 100 points you could make. One is the effect of Snowden turned out to be even bigger than a lot of people realized. So at the time the Snowden papers came out in early 2013 in June, GDPR was dead. It wasn't going to pass the European Parliament. And it's clear when you look back at the record that when it then passed by 600 something to 15 or whatever, that the sort of concern about the NSA was enormous and really drove the political process and drove it towards a stricter version than it would have been without Snowden. And we saw that in the first Schrems decision, where there was language in 2015 by the court about unrestricted, unconstrained surveillance by the US. In my testimony in the Schrems case, I wrote 300 pages explaining the many constraints that exist under US law on the NSA and how there's a very strong case we made that there were the strictest sets of intelligence restrictions of any country, any of the democracies. And under European law, that's not relevant because they're not testing us compared to Germany or France. They're testing us compared to the CJEU standard. So we have a series of strictness about concern based on Snowden in part, that the NSA is and the tech companies of the US who somehow are subject to the NSA are driving a surveillance problem that needs a massive solution from Europe. Given that, however, finding workable ways to do the transfers has not been the priority of the CJEU. And we saw Van Damwitz, the lead judge on these cases in December, saying, well, I thought you could use a bunch of derogations. And he gave a speech being surprised that the derogations he thought would be in place are not consistent with what the EDPB has found to be appropriate derogations. So there's a strictness beyond what I think maybe even the court realized. And when you look at the EDPB guidance on supplemental safeguards and the use cases, most use cases appear to be illegal under the EDPB guidance. And lawyers are struggling to find ways to do things lawfully and find ways to say they're supplemental safeguards. But the language from the court and the language from the EDPB put together put in doubt a huge fraction of data flows in the modern world.